You guys have lots of enthusiasm. Don't ever lose it because it goes downhill after a while. All right, so opening statements. It's really the beginning, right, of your speech to both the judge as well as the scoring panelists. So first question is, why is the opening statement so important? Go ahead. What's your name? Blake. Sure, it sets up the tone, the storyline. And what's your name? Okay, Victoria. Nice. And final one. I mean, all of you are right, but I'm actually really impressed, frankly, because when I was in high school, all I cared about was how do I get an A, right? So really, on the judges' grading sheets, the factors that the judges consider when judging your opening statements are listed right here. So I think Victoria talked about, or actually it was Blake that talked about providing a case overview. You know, obviously you're going to have to mention the key witnesses and what their anticipated testimony will be insofar as it supports or negates your case. And obviously you're going to ask for a specific form of relief, right? My client should be found not guilty. Make sure you don't leave that out because really that's the conclusion of your opening statement, right? And it basically shows to the judge as well as the scoring panelist how prepared you are in the case. We'll talk about the specific elements, but I did want to go ahead and tell you that, you know, where it says factors to consider in scoring, I mean, that's the exact verbiage on the scoring sheets that your judges and your scoring panelists have. All right, so over here in the blue, we had a discussion on theme. So your opening statement is a place to really get down to a theme. So after you've read, you know, your case, and depending upon what side you're on, you're going to have to determine what kind of theme. So some of the themes, for instance, is this is a case about taking chances. If there were lots of chances and risk involved within a particular fact pattern, then that might be a really good one. Mary Jones had a dream and a plan. Well, how was Mary Jones's plan or dream cut short? Was the other party responsible for it? What evidence do we have to prove that? And so again, just focus on the theme revenge. Here's another, that's what this case is all about. And how many of you watched the Trayvon Martin case? All right. And you obviously know that there were Skittles and he was unarmed, right? What do you think the defense did insofar as proving that he had a weapon? What's your name? Matt. What did the defense do? Sure, absolutely. Yep, and to be honest with you, I mean, y'all think that there was no weapon involved, right? But what the defense did was they actually literally cut out a piece of a concrete slab, and they were basically asserting that the sidewalk was Trayvon's weapon. All right? I mean, so you can get pretty creative with things like that. But again, you know, Mr. Johnson's only companion today is pain, right? That sets a very emotional draw for the case. And again, you know, police brutality, Rodney King. Okay, so we're going to cover what to do and what not to do. You should focus on personalizing the case as much as possible, whether you're the prosecution or the defense, right? If you're the prosecution, you want to talk about how this person's actions have affected negatively their family, their community, their municipality, their state, any dreams or ambitions that this person had is now dead. You know, if you're taking regular speech class, you've probably heard of the Aristotelian proofs like ethos, pathos, and logos. And so when we talk here about being emotional, we're playing to the pathos appeal, which is the emotional appeal. Also, make your story vivid, right? If you've ever visited the place, then talk about it. If you Are there certain smells, colors, those types of things associated with the fact pattern? And remember, you only have 5 minutes, right? So you've got to, get it down to the bare bones of the outline of your case. And obviously, you're going to provide a roadmap for the jurors as well as the scoring panelist. And so if your roadmap or signposts aren't clear, then that's going to be problematic. And so a way to sort of get that done really easily is just to put things on a temporal or chronological plane, like first in time to last in time. Or you can do it backwards, depending upon how creative you want to get. So that's what to do. What not to do, don't assert any personal opinions. Don't overstate any evidence. If you say you're going to prove something and you don't, well, the judging panelists are going to mark you down for that. So make sure that, you say only the things that you can actually prove. You only provide witness testimony to the extent that it's absolutely true. All right? Okay, so your secret weapon, depending upon what side you're on, obviously, is to anticipate weaknesses in the opposition's case. And so that's going to, hopefully you're with a school that has 2 teams, but if not, you can always split up your team and be devil's advocates on either side. But you really do want to evaluate both the factual as well as the substantive evidence. What I mean by substantive is, charging sheets, diagrams of any places, that kind of stuff. But you want to find holes, and you're going to find holes in your own case, right? And the best way to deal with those is to anticipate the defense's use of those facts. So if you stand up and you concede to certain facts, then that kind of lets the judging panelists know that they're saying, okay, well, gosh, this team must have some sort of legal argument to state if they're just going to go ahead and concede to these facts. So when you concede those facts, though, understand what you have to overcome. All right? Okay, so we talked about themes, theories. I do want to talk when the difference between themes and theory. I don't want you to get so bogged down. Themes is probably going to be based on your fact pattern. Theories are probably more going to be based around like the area of law. And also set up in your opening statement, right? In terms of theory, what is the standard of review? What is the burden? Is it clear and convincing evidence? Is it beyond a reasonable doubt? And state plainly that if one side doesn't reach that, then obviously the ballot should go to you. So when we talk about theory, we're talking more about law. Enthusiasm. You guys have no shortage of that, so I am not worried about your enthusiasm. Confidence and integrity, that's a little bit more difficult, right? The more you practice your opening statements, the more confident you're going to be with it. If you've taken a speech class, you know that there are different types of delivery. There's memorized, there's impromptu, there's extemporaneous. For the plaintiff or prosecution side, obviously you're going to have it pretty memorized. However, on the defense side, right, that's where you can really shine, is if you're a really good extemporaneous speaker. You know the fact patterns well enough to have listened pretty thoroughly to the prosecution's opening statement, and so you're able to sort of interject something that isn't necessarily memorized, and your judges will really appreciate that. So honestly, it's all about practice. So as long as you're practicing, you should be just fine when it comes to the actual trial. So confidence and integrity, obviously the integrity portion has to do with, telling the facts as they are, not exaggerating them, no hyperbole in terms of the law for that matter. So just make sure that, you practice, and if you practice, the confidence will just show, honestly. All right? It helps to, when you first start out, I would say it's fine to go ahead and have a script written, but eventually what you'll probably want to do is take that script into an outline format so that you can speak extemporaneously. If you've written every word verbatim, the problem becomes that you forget a word and then you're stuck. All right, so try to eventually move from the memorized delivery to the extemporaneous delivery. Okay, so in your opening statement, you're going to introduce the parties, and that also means introducing, your colleagues in crime, right? Any pertinent witnesses, all of your attorneys, and so, in terms of the parties, I want you to focus on, the different sides, right? So if it's the prosecution, then obviously somebody is dead or maybe somebody has committed a crime. So how has this crime affected the local community? Does it affect state or national concerns? And if it does, you might want to, mention the impact of that in the beginning. In terms of the defense, if you're defending, obviously then you want to downplay any crimes that the person being charged has committed or allegedly committed, and make sure that that you've found the holes in each side of the case so that you can either highlight what the prosecution just glossed over because they know that's a weakness in their case. And if you alert the judging panelist early enough in your opening statement that that's really going to be an area of contention, they'll listen to that closely. All right? So defense, focus on the important witnesses, any potential exhibits that would be meaningful to the case. And again, does anyone remember the Aristotelian proof for emotions? Pathos, nice. Okay, so you're going to want an emotional appeal, right? You're going to want an emotional appeal for the defense client. Build them up. Make sure that the jury can relate. Okay. Describe the scene. Make sure that they can visualize it, right? So depending upon the fact pattern, this is it's going to be based on what they can feel and see. And I want you to think about that, though, right? I mean, why is the scene so important? If there's a raging river nearby, can you hear everyone pretty well? I don't know. That's something that you're going to have to answer. So don't neglect the scene. Instrumentality. How were they killed? What crime did they commit? Was there a needle involved? Those types of things. You want to address that. And again, date, time, weather, and lighting. There are these things called sunshine laws that they actually have to give you when the sun rose and sun set. So think about those things in terms of the entire context. And then you want to roll it down like we talked about earlier into a theme. You want to highlight and deny what they did. And honestly, this is really, you've got 5 minutes to really give it to them. So make sure that you shine, because this really sets the tone for everything that happens in your case is the opening statement, all right?